Good afternoon, everyone. I'd like to welcome you to today's presentation on the Canada's anti-spam legislation. This is one of a series of events that we're holding at McInnes Cooper on CASL. There's one that's been recently presented in Halifax, as well as one in New Brunswick. My name is Trent Skanes. I'm an associate in the Corporate Technology and Privacy Law group here at McInnes Cooper. And I guess as the clock counts down to CASL, we only really have about 3 business days left until this thing launches. So today is really going to be quick hits about what you can do right now, sort of try to give you some practical advice on what you can do in the next 2 to 3 days, and then maybe what types of things you want to think about over the next, in the coming weeks and months. CASL is a bit strange. It's a broad act. It's very sweeping, and it kind of is counterintuitive in ways. There's things that are defined in the act, like existing business relationship and consent, that normally would be terms that we would be familiar with, but because it's defined and has a specific meaning, you have to really understand what those meanings mean in the act and the regulations. There's also some strange application in terms of who has to comply with the law. American companies who are sending in messages into Canada, the law actually purports to cover them as well, and I think a lot of them will be caught off guard. Small businesses, medium businesses, large businesses, all businesses basically sending any kind of commercial messages are going to be affected. This includes not-for-profits and registered charities in different ways, and we'll try to get through a little bit of the ways it might affect registered charities and not-for-profits, but it may require a bit more specific advice to your particular circumstances. So at the end of this session, I'd ask you that you please hold your questions so that we can answer them at the end during the Q&A, and if there are any particular questions that I can't answer to your satisfaction here, I'd be happy to address them during any sort of follow-up session directly with myself. So I'd like to get going on the slide presentation, so just one moment here. All right. So as I mentioned, it's a sweeping law, and it wouldn't be a legal presentation unless it had a couple disclaimers. First disclaimer is it's just for educational purposes. It's not intended to give legal advice. So if you do need specific advice, as I mentioned, please talk to myself or one of our CASL team members, David Fraser in Halifax and Thomas Raffi, and you can find those on McInnesCooper.com, and we'll take care of you. As I mentioned just then, most businesses will require specific advice. Disclaimer number 2, I didn't write the law, so it's not my fault that it's so sweeping. It's not my fault it affects your organization, and we actually did try to fix it. Our partner David Fraser in Halifax stood before the parliamentary committee just 2 weeks ago trying to take away some of the impact on small businesses and some of the more controversial aspects of the law, but to no avail. So here we are dealing with it 3 days beforehand. In terms of what I'd like to talk about today, we're going to go through sort of a background of how the legislation came into force. We're going to talk about not only CASL itself, but the regulations that support CASLs. They're very important, and they have specific sort of areas where they carve out and really redefine what might be otherwise intuitive concepts. We're going to talk about the general rules and the key concepts being content. So what do we actually have to have in the messages for it to comply? And then what types of consent are okay? Because consent is sort of the key principle to the whole thing. And there'll be different types of those. As I mentioned, forms of consent. How to obtain consent. So you're probably seeing messages flooding your inbox about, would you please consent to us continuing to send XYZ messages for XYZ purposes? This is actually a method that people are using before July 1st to kind of clean up their databases that already exist. We're going to talk a little bit about the violation and penalties, as well as how the CRTC intends to enforce this law. We gather as a firm that they're pretty excited about becoming a law enforcement agency, and they might actually be a little more aggressive out of the gate to try to, name and shame violators. And as I mentioned at the outset, things you can do to prepare right now, both in the next few days and in the coming months. And I should mention, if you're online and you'd like to ask any questions, please feel free to post it on the Hangout page or on Twitter at #MCCSAL, and we'll deal with it at the end. As we go through this, these are the sorts of things I'd like you to keep in mind, what I call the burning questions. What kind of messages are caught? So there's certain types that just you won't need to worry about. If they're just strictly informational and they don't have any commercial element, then you should be okay. What are the content and what are the functionality requirements? Do we have consent? What happens if we don't comply? And what should we do right now? So those are the 5 things that really are the takeaway to this whole thing, and that I'd like to answer for you generally speaking today. This slide just kind of really hammers home the point of what we're talking about here today in terms of how broad the Act is. On the left, we have my colleague David Fraser's son, who's selling homemade lemonade and chocolate chip cookies on the street, and on the other hand, on the right-hand side, we have what's commonly called a phishing scam email, which is trying to kind of take your sensitive information and use it to steal your personal information, credit cards, etc. Of course, the one on the right, we all know that's spam. We're all used to seeing that. It's flooding our inboxes all the time. You got to be careful. But the one on the left, we wouldn't traditionally think of as spam, especially if, you know, the young sir here sends off an email to his friend saying, hey, I'm selling lemonade tomorrow and chocolate chip cookies. You wouldn't necessarily think that's spam, but under this new law, they're both spam. So up until now, July 1st, there was no specific law that dealt with these types of messages and how they're sent to customers, clients, and otherwise suppliers. We did have privacy laws that dealt with collection, use, and disclosure of personal information, and how, like, for example, email addresses, how you can collect them, how you can use them, but not the sending of your own messages from your organization. There was also criminal code provisions, so for the more severe frauds, for the more severe impersonations. And up to this point, Canada had been one of the few developed economic countries without an anti-spam law. And since they waited so long, they decided to really pull the hammer out, as it's probably the most aggressive anti-spam law in the world right now. So the law has been passed. It actually went through Parliament in 2010, but just hasn't been will not yet be enforced until July 1st. And some people are surprised to know it's been around, and they have gone through a number of consultation processes to kind of clean up the guidelines, but there's still a lot of gray areas that haven't been addressed. And as I mentioned, it will mostly come into effect July 1st, 2014. There's parts of it that don't come in until later, like if you're installing computer programs, that's 2015. If you're trying to sue as an individual, like trying to sue an organization for sending these messages, that won't kick in until 2017, and we'll get to that. But for our purposes today, any sort of messages you're sending out, that's happening next week. So how do we get here? Canada had an anti-spam task force that they sort of put on the task in 2004 and reported back in 2005. And the key about this whole thing, in terms of the timeline, is that it addressed spam as it existed 10 years ago. So 10 years ago, there was no social media. There were no phishing scams. You just had piles of email cluttering up your inbox and no spam filter to deal with it. So when this started, it really hasn't switched gears to deal with some of the more innovative and new technological problems that come with sending these commercial electronic messages. So that's something to keep in mind, is like, why is it structured this way? Why is it not dealing with certain things in the way it should? It's because it hasn't really stepped up gears and joined up with where we are today. So the Spam Force ultimately recommended that we need to move Canada to an opt-in rather than an opt-out regime. So that's where consent comes from. It's the whole notion of, we want people to opt in, and only people who've opted in or somehow otherwise given consent should be receiving these messages. We're not going to allow you to have a toggled checkbox and force somebody to toggle off to stop sending the messages. They need to actively opt in. And if you don't follow those procedures, then you're committing an offense under the statute. In comparison, we have the American legislation called the CAN-SPAM Act, which basically only applies to emails. It relies on an opt-out, so as long as you don't opt out, you can continue to send that user messages. And it applies only when the primary purpose of the message is commercial. And that's a crucial difference, because what we'll see as we get into this is CASL covers if any content, if any purpose of the message is commercial, not just the primary purpose, then it's going to be caught by the legislation and needs to follow the requirements. Ours also requires express consent, and it applies to more than just emails. It's instant messages, it's text messages, and more examples of telecommunication messages. So basically any kind of telecommunication. This is the actual name of the act. I know it rolls right off the tongue, but it's been shortened to Canada's anti-spam law, referred to colloquially. Basically, the only reason I put this here is to show you it does affect a number of other acts, such as the Privacy Act, the CRTC Act, the Competition Act. So there's a whole scheme of things that the federal government is trying to do to make sure that this is going to be sort of the driving force behind spam, and sort of making sure all the other acts that are affected are in accord with this particular piece of legislation. So here we have CASL itself at the top. That's the act. And then we have, just recently, the government issued a series of regulations underneath it. So the Electronic Commerce Protection Regulations, which define certain things like what is a personal relationship, what is a family relationship. It also provides what types of messages are completely excluded, such as registered charities when they send messages for a primarily fundraising purpose. There's a whole series of exclusions that don't require you to have consent and don't require you to have specific content requirements. So we'll probably touch on them a little later in the presentation. And also that the Electronic Commerce Protection Regulations deal with conditions for consent obtained for others. So that's what's called the unknown third-party consent. So if your organization seeks consent on behalf of someone else in the future, like we would like to be able to provide your name to organization B, who will then send you messages, that's covered off. There's also the telecom regulatory policy, which deals with what are the exact content requirements that have to be sent out and what are the consent requirements, and we'll deal with those. So as I mentioned, of course you know it covers spam because that's why we're here today, but it also covers the installation of any software. So really this is addressing spyware, malware, sort of those pop-ups, sort of the things that you don't want on your computer that's clogging up your operating system. It just has specific rules around consent, and if you need, this is not going to be focused on that, but if you do need advice on that, we're happy to provide it. Also, any alteration of transmission data. So that's kind of a fancy way of saying if you're an organization who sends out messages but cloaks the sender, so you're trying to hide who you are when you're sending the messages, or if you're taking a message and you're rerouting it to a series of different recipients who didn't give consent, that's altering transmission data, and that's also going to be covered. We're not going to talk any more about that today. So when it comes to the force, these are the sorts of keeping in mind the general prohibitions of where you might get in trouble and what it's trying to prevent. So sending of, quote, commercial electronic messages, which is a very loaded term, we're going to talk about it, without consent and without certain content, altering transmission data, altering computer programs, using false or misleading representations. That's already covered in the Competition Act, but as I mentioned, CASL is sort of putting itself over the Competition Act to also prevent that. And I don't believe any organization who's here today is using false or misleading representations, but that's covered. Again, collection of personal information and collection of electronic addresses also kind of prohibited unless you have consent. So what is a commercial electronic message? This, I don't like putting out fully loaded text slides usually, but this is very critical because there's a lot of different ways you can interpret this, and there's a lot of gray areas. So it's an electronic message. So what's an electronic message? We'll get to that. That looking at the content of the message, the hyperlinks in it, or the contact information, it would be reasonable for what's called the objective person, so somebody, a kind of a neutral third party looking in on it, that one of its purposes is to encourage participation in commercial activity. Encourage participation, so not carrying out commercial activity, not fulfilling commercial activity, but to encourage participation in further commercial activity. And then they give a bunch of examples. These aren't exclusive, so if it still has a purpose that encourages participation in commercial activity, it's going to be a commercial electronic message. But some of the more, I guess, prevalent examples are offers to purchase, sell, barter, or lease a product, offers to provide a business, investment, gaming opportunity, anything that advertises or promotes those two things, or, and somewhat problematically, something that promotes a person, including the public image of a person as being a person who does anything of those first three things. And if you think about it, many people use their email signature taglines to sort of say, hey, we have this great opportunity coming up, or we have this event coming up, or 20% off for the next 3 weeks on XYZ inventory. That email signature can itself transform an otherwise innocent email into a commercial electronic message, because you're sort of promoting yourself as a person who can provide these discounts. And that's sort of a gray area and fairly controversial, but it's something that we felt was worth pointing out as we work our way through this definition. And I think this is something probably more so than a lot of other concepts in the Act that's going to be having to work its way through the courts in terms of what exactly does it mean to encourage participation in a commercial activity. There's lots of things that are on the line. There's lots of things that are around it. What does it mean? We don't have a perfect answer yet because it just hasn't. There's been no guidance. Another few key terms that fall out of both that previous definition and generally, what's an electronic address? It's not just email. Like I said, it's instant messaging, it's phone address or any similar type account, so text messaging basically. What is commercial activity? It's not just profit-based activity. It's any activity of a commercial nature, even if there's no expectation of profit. That's important. And what is an electronic message? It basically, the CRTC and the government of Canada just said, you know, anything that deals with telecommunication. So any kind of text, sound, voice, or image that you send electronically. But, and this was sort of something I was confused about at first, and until I saw this, it doesn't include interactive two-way voice communications. So no matter what the Act says, you can still pick up the phone and call someone, and you don't need to say, you may unsubscribe from this phone call. So you're still okay to call somebody. So in a way, it's sort of kicking us back to the Stone Age, or, well, not the Stone Age, but when the phone first came out, trying to say, you know, pick up the phone and call somebody. So as a summary of these rules, they apply to, as we mentioned, electronic messages, and it's worth noting that it's no minimum number. It's not just mass mailing. It's not just our traditional notions of spam. It's any email. It could be one email, and if you have that tagline and it's promoting commercial activity, and it doesn't fall within all the exclusions that are kind of sometimes over-inclusive, sometimes under-inclusive, then you could be caught. But it has to be, even if it's just one message, it's an electronic message, it still has to have these things. It has to be by telecommunication, it has to be to an electronic address, so not broadcasting stuff, for the purpose of encouraging participation in commercial activity, and only if the computer system located in Canada is used to send or access, which for our purposes today is basically everything. So what about social media? This is sort of one of the gray areas that I mentioned. It's kind of questionable as to how does social media play into all this. There's no regulation that deals with social media or kind of talks about it, and we only have verbal assurances right now that there's a regulatory analysis policy that says social media is not within the intended scope of the Act if you're not sending direct messages. So if you're posting on your Facebook wall, if you're posting on your LinkedIn status update, if you're sending around a tweet, then you're usually going to be okay, because that's just passive broadcasting, okay? You're not sending it directly to an electronic address. Someone's got to go to you to find it. But if you're using the Facebook messaging service to sort of say, hey, we've got this event coming up, and you're trying to send it to all the people who've liked your page, that's probably not going to be okay unless you have the unsubscribe feature and you have the consent to do that. If you're sending direct messages over LinkedIn to say we've got an event coming up, that's something you got to be careful for as well, because that's sending a commercial electronic message to an electronic address. So all of a sudden you find yourself within the boundaries of CASL. So I think that was, you know, something you keep in mind. And again, not well defined. Basically, CRTC is saying we don't really want to capture social media. We don't want to impede social media usage. But if you are using it within the boundaries of sending a commercial electronic message to a person, you're going to have to be careful. So the two rules, consent and content. These are straight from the Act. The consent rule itself, Section 6, Sub 1. No person shall send or cause or permit to be sent. So if, you know, it doesn't have to be you, it could be someone in your organization, to an electronic address, a commercial electronic message, unless the person to whom the message is sent has consented to receiving it, whether the consent is express or implied. We're going to deal with both of those. And the message complies with subsection 2. Subsection 2 is the content rule. So the message must be in a form that conforms to the prescribed requirements. So basically there's stuff and regulations you also have to do. And these three things. Very critical, very important. If you're going to take any notes on anything, this is one of the things. Identify the person who sent the message very clearly. It needs to provide, and if as well, if there's any affiliates, like if you're having an event and it's not just you, but it's your sponsors, or it's, you know, a branch of your organization who's also partnering at that, if it's a joint venture, you're going to need to identify not only your own organization, but the organization who you're affiliated with, or whose behalf you're sending it. You need to provide contact information so that someone can readily contact one of the people sending the message in paragraph A. And you need to set out an unsubscribe mechanism in accordance with subsection 11, and that kind of will go through exactly what needs to be in an unsubscribe and sort of how you might want to customize it so that it works best for your organization. But those three things are key. Then the statute kind of dives into this really nebulous area of providing limited exceptions to consent. So you don't need consent, but you still need to follow content. So these things are very interesting to me because they seem like all they're doing is carrying out a transaction. They're not encouraging further participation. But according to the statute, as it stands right now, you need to have the content requirements. So you need to identify yourself, you need to have contact information, and you need to unsubscribe. If you're providing a quote or estimate, if you're sending a message that facilitates, completes, or confirms a transaction, if you're providing warranty recall information, any sort of factual information about the transaction, you don't need consent to do this because presumably you're in the process of a transaction, but you do need to have the content in there. Referrals is a very specific regulated area. It sort of deals with anyone who is dealing with referral marketing. So if you rely on referrals to do your business, it's very much an area that's still in flux and needs some guidelines. Basically, if my organization and your organization have a transaction or somehow have a relationship, then you, as the referee, can decide to say, hey, well, Organization C could really use your advice as well, so I'm going to pass your contact information along to Organization C, or I'll just give you Organization C's contact info, and you can send them a message. That's a referral. You can only send them one message. So you're only allowed to send them one commercial electronic message to Organization C based on that referral, and you have to identify yourself, why you're sending it, who provided you with the referral, and so basically to give full disclosure on what this whole referral thing is all about. One issue with that is, of course, we all know some people don't respond. You can't send them any follow-up. So you get one message, and if they don't respond to you, then you can't email them. You can call them, or you can call back the person who provided the referral and say, hey, look, I sent them the message, they didn't get it, or they haven't responded. Can you just touch base with them and sort of put us in contact? But that is sort of a blockade right now in terms of referral marketing that CASL's put in place. And I just made a note, and we already talked about it. Are those first four things really commercial electronic messages at all, if they're just carrying out activity rather than promoting it? Because if they're not commercial electronic messages, then you don't need consent or content. But according to the statute, those first four things, you still need the content. So there's a bit of dancing around there that you need to do, and we're still waiting for more clarification on that. These are completely excluded under regulation. This was the new regulations that came in December 2013. You don't need consent, and you don't need to follow the content requirements for the following: employee to employee within the same organization about the organization's activities. So, hey guys, we're having a bake sale today. You can buy tickets in the kitchen. You don't need to unsubscribe from that, you know. But it's got to be about your organization's activities or your branches. Employee to other organizations. First off, one, if those two organizations have a relationship, what does relationship mean? We don't really know, because relationship itself is not defined. We know what a personal relationship is. We know what certain types of business relationships are, but we don't know what just relationship means. Prior business dealings probably gets you there. Some sort of joint venture probably gets you there. It'll be fact-driven. So you can send it to another organization if you have that relationship, and if it's about their activities. So it can't be about your activities. It's got to be about theirs. So I think there might be another gray area in terms of how you have to dance around things a little bit by saying, hey, this is about us together, this is about yours, when really what you're trying to do is promote your own activities. This is something that needs to be clarified. Again, you don't have to follow consent or content if you're just responding to a request, an inquiry, a complaint. So if someone has actively sought you out and sent you a message, you don't need to worry about sending message back with an unsubscribe function, although maybe the safest thing to do these days is just have it there. Certain messages in closed messaging systems, so that have a protected back end. So when you go in and you sign into your banking account, they'll send you messages directly, and that sort of thing is protected, and they don't need to follow this. Registered charities and political party fundraising. If the message is for fundraising, the primary purpose has to be fundraising, then you don't need to follow consent and content, which means you don't need to have unsubscribe, you don't need consent, but only if the primary purpose is fundraising. And what is fundraising? I'll try to get more into that later, and I might be able to address it in questions, but certain cost recovery events where you're just trying to make back certain elements rather than directly fundraising, that's sort of right on the borderline. If you're selling tickets to a golf tournament or a dinner, then that's usually seen as safe. But there's certain things, and I can't think of an example off my head, but that may still require the content and consent. Again, where the message is not a commercial electronic message itself, if you decide that, hey, this is not promoting commercial activity, I'm not going to worry about consent and content, that's your prerogative, but you just want to be careful, because if you do fall within it, then and you don't have the consent and content, then you'll be in violation. Also, if you have a personal relationship or family relationship with somebody, then you're okay. Family relationships, mostly blood relations, the type of things we usually think of. Personal relationships, it's sort of voluntary two-way communication with somebody that, and objectively, it would look as if you had a personal relationship. That's how it's defined in the Act, and they look at things like, do you share interests? Do you share opinions? Have you met in person? Have you communicated, routinely with these people? And this might be important for sort of if you know someone at another organization and you guys are the link for a particular event or activity on both sides of the organization, maybe you can circumvent having to have consent and content if you can show you have a personal relationship with that person. But that's something that you got to tread lightly on. So in terms of how the rest of this will go, we're going to talk about the two types of consent, which are express and implied. Express being oral or written, implied being certain categories such as business relationship or non-business relationship. And then the two types of content, which I'll discuss first, are what are you disclosing, and we've kind of gone through those in detail, and what exactly do you have in your unsubscribe feature. So as I already put this in there, so I'm not going to spend any more time on it, you're going to identify yourself and your affiliates, you're going to set up contact information, and you're going to set out an unsubscribe mechanism. This is straight from the regulations in terms of how do you identify yourself, because they actually drill down and provide even more details of what you need to provide in that message sort of at the bottom. So you need to have the name of the sender or the name of your affiliates or the name of the person on whose behalf you're sending it, and you need a mailing address. So that's the second thing you need, and you need one of the following: telephone number, email address, or website address. So there's really three things, and you can choose from that little list at the end there in terms of how you want to do it. If you don't want to provide a telephone, that's fine if you have an email address, and vice versa. But you need a mailing address and you need your name. The unsubscribe itself has to be readily performed, and it has to be clear and prominent. You can't have an unsubscribe feature that's, it'd probably be bad practice to have it below the cut in terms of having you scroll down to find it. Also, probably bad practice if it's light gray font on a white background, sort of trying to skirt it past, like, oh yeah, I don't really want you to unsubscribe. We're gonna make this as hard as possible. They're just really trying to hammer home, like, we want this to be real simple, real easy. Just make it obvious. If they want to receive messages from you, they're not going to unsubscribe anyway. That's sort of the rationale. And then further into the unsubscribe mechanism, what does it need to do? It needs to allow the person at no cost, so you can't charge $5 per unsubscribe or anything like that, their desire not to receive messages from you. This could mean doing it, their preference is to have it the same means by which the message was sent. So if you're sending a text message, sort of what the regs have talked about is allowing a user to just text you back stop, and that should be sufficient to unsubscribe. Or if you send them an email, they should be able to either click unsubscribe and it's done, or like a two-click where you click and you go to a landing page, stuff like that. And one point I want to make before I go any further: if you're using unsubscribes in the emails messages, then what you might want to think about is having a drive to a landing page with a series of checkboxes saying exactly what are you unsubscribing from. It may not be everything. You may have different things you're sending them stuff for. So just make sure that they can indicate exactly what they want to unsubscribe from, rather than just having a blanket unsubscribe and not being able to send them messages anymore. That's only if your organization has, you know, particular things that they send out more than one type of message or more than one type of communication, then you want to think about that. The unsubscribe feature, or the link that you send out, has to be valid for 60 days. So if the user gets it, clicks it, 40 days later, they're going up to clean up through their email, and all of a sudden it says this web page has expired, that's a violation. And if you do receive an unsubscribe request, you've got to take action without delay, and that means no later than 10 days. So you can't sit on it. You have to have some sort of flagging mechanism in your databases for it to say, you know, pop up with unsubscribe request or what have you, something that clearly indicates to your organization that you need to, you know, scrub them. And this is an important point, and I'll get into it more in implied consent, but I'm mentioning it here because it's unsubscribe. Even if they unsubscribe, if they later enter into another transaction, you then have implied consent to send them something else. This is where it kind of takes a break from reality, and you might want to be careful, because if someone unsubscribes from your stuff, they probably don't want to get more stuff unless there's a real reason why they would want to. So practically, what some organizations do is set up a block list for those who want to subscribe to say, we will not, and a lot of third-party messaging software will actually do that for you if you're using something like Constant Contact. Anytime someone unsubscribes, they'll be by default placed on a block list, so they won't get anything else. But the statute allows you to send more messages if they do another transaction that gives you implied consent to do so. So just keep that in mind. You're legally okay. Practically, you might want to be careful with doing that. You might frustrate some people. So moving on to exactly the two types of consent. As I mentioned, you need express or implied. These are all defined. And the onus is on you to prove it. So if you're relying on express consent, which never expires, by the way, once you have express consent, it never expires, you will need to prove it. So when did you get it? What was the date you got it? What was the time you got it? What was the manner you got it? What was it in relation to? And you will be required to pull this up and show, if you're investigated by the CRTC, that you actually have express consent. A note on that: the express consents you guys already have flagged in your databases, and you're comfortable with their express consents, they're going to transfer into the new regime. So they're going to grandfather in, for lack of a better word, as long as they're semi-reasonable. I mean, you can't just make it up that you have express consent. You have to you should be able to somehow back it up that yes, you have express consent. Because I know a lot of people's databases, especially if they're a few years old, they might just be an Excel spreadsheet that plops in someone's email, and you don't really know how you got it. You know it's there. You don't really know what channel it came from. So you might be best off trying to get it again. But old express consents that you feel comfortable with will be okay for the new regime, even though the new regime is going to, for new express consents, to have extra requirements. Yeah, hope that makes sense. And consent is implied only if, one, there's an existing business relationship or an existing non-business relationship between the sender and the recipient, or the recipient has conspicuously published or disclosed the address without indicating that he or she doesn't want to receive unsolicited messages, and the message is relevant to their business role. So this is commonly called the business card exception. So someone gives you a business card, they've obviously published their contact information. Unless it says somewhere, I don't want to receive solicitations, then you're good to go. And as long as it's relevant to what they are actually doing. So you need to look at their business function and say, okay, this message has to be somehow tied to their business function. It also works for, say, if you're on a blog and you want to send the blogger some messages you think might be relevant, then it has to be in relation to their role, and they make sure they don't have a little tagline at the bottom of the blog that says, don't send me any messages, because then you'll be offside. If you're trying to rely on the existing business relationship implied consent category, they have the users have to have taken a positive action. If you've sent them promotions or advertisements in the past, there's been some confusion about this, and some people have said, no, this is okay. If you sent them stuff before, then you have a business relationship. That's not true. They need to take action. So there needs to be a transaction within the past 2 years. or an acceptance of some sort of opportunity, a bartering transaction, I'll trade you chickens for goats, okay, you're good. And then another one, if there's a written contract in force or has expired in the past 2 years. So former employees, suppliers, any sort of partner that you're doing a joint venture with, anything that is based on a written contract, you have that business relationship which gets you to implied consent, which then means all you have to do is follow the content requirements. If you have an existing business relationship before July 1st, you'll actually get 3 years. So you have 3 years to turn these implied consents into an express consent. So you can send them, requests for express consent for particular purposes. Those timelines of 2 years, 2 years, 2 years and stuff will only be for new business relationships that you guys get after July 1st, 2014. But if you have one in place right now, you've got 3 years. So you can essentially stop the clock by getting, if you do happen to get a new business relationship before July 1st, so before Tuesday, then you also have 3 years. Anything before July 1st, 3 years. Existing non-business relationship. This is important for not-for-profits and charities to an extent, because charities are sort of excluded in a lot of cases anyway. If someone's made a donation to the sender, if you're a registered charity in the last 2 years, then you have implied consent. On top of being excluded for fundraising purposes already, you have implied consent for other types of messages that you want to send. If you're a registered political party or candidate, I'm not sure anyone here online is, but if you are, then you also have implied consent based on this type of relationship. If there are past volunteers for charities, then you're good. Or if they're a member of a club, association, and so forth in the last 2 years, and sort of the regulations takes a stab at defining the clubs and associations. So they're essentially covering not-for-profits, so anything in place for social welfare, civic improvement, recreation, or even amateur sports. And amateur sports is a little different because they can be looking at profit. They don't necessarily have to be not-for-profit. So that's a little too specific for today. But those are the sorts of things that get you implied consent based on this relationship. In terms of seeking express consent, there's certain things you actually have to include in that message. And these are the things that you've probably seen flooding your inbox. They all kind of look the same. It's because they have to. You have to disclose why you're asking for this express consent. So what is the purpose? Why exactly? And you're only going to get consent for those purposes. So if you can frame it broadly, it's probably smart. But you still have to have a purpose. You can't just say, I'm seeking your express consent for everything. That might be troublesome. You might be able to get away with it. Not sure. You can request it orally. If you do request it orally, you have to have some sort of audio backup. So it's good for call centers and things that actually have contemporaneous recordings. But if you're seeking it orally, you probably want to, if you're dealing with a colleague and you're asking them for consent, or you're doing business development and you're requesting consent orally, you want to turn that into written probably if you can, so you have a better record of it, because you're not going to go around with a tape recording device trying to, get all these oral consents recorded. Also, providing your identity and contact information, you have to do the same thing as if you're providing content in a message itself. And then the only thing that really is added in this one is a consent withdrawal statement. So in your request for express consent, you have to state you may withdraw consent at any time. And you probably see these in the messages that you sent out. And in terms of timing, this is probably the most important slide, because you can't send such a message for someone who doesn't already have consent. You're asking for express consent. You can't do this after July 1st because it will itself be a commercial electronic message. So if you're on the fence about doing it, you're best off just doing it the next 3 days, putting something together and sending it out to try to clean up your database. If you don't know where the consents came from, if you're uncomfortable what they look like, then put something together tomorrow, Friday, Monday, and just get it out. And then I already spoke with the transition provisions. That's if existing business relationships are in place. You'll stop the clock and turn it into 3 years instead of 2. Just as a practical point, I guess, I've noticed a lot of organizations have sort of packaged in prizes, discounts, some sort of incentive to get a response when you send out this request for express consent. because the no answer rates are fairly high. Like people just will not, people don't like seeing this stuff come in. But I noticed like Ford Canada did like win a 2015 Mustang, enter a draw for a Mustang, or you can just do you can do whatever you want before July 1st because there's no regulation in place for this type of thing. So you might want to think about what can we do in our organization to make it more attractive for someone to say yes, I consent before July 1st. This is an example of what you can and can't do in terms of the toggling when you're seeking the consent. On the left, you have something you can't do. It's a pre-check box, and these images come straight out of the CRTC manual on this. You can't have pre-toggled boxes because that's an opt-out. We're looking for opt-ins. So on the right-hand side, there's an unchecked box. You're about to purchase this. I also agree to receive Company Inc.'s newsletter containing news, updates, promotions. That's fine. The only thing I'd mention on that is you can't be sending out a gigantic contract for someone to sign and at the very bottom kind of bury a request like this. It's not going to work. First of all, you'll get no uptake, but also it probably won't be acceptable. And this is another example of what you can do when you're seeking consent over email. You can provide people in person here. It's a bit white, but on the bottom there's actually a text box to enter your email address. So instead of just toggling a box, if you just have a little text box that shows, here, put in your email address, as long as they know why they're doing it, as long as they know what it's for, then that's okay. So I just wanted to speak briefly on violations and penalties. As I mentioned at the outset of the presentation, the CRTC is fairly excited to be a law enforcement agency now. So they're probably going to take it fairly seriously at first, and until there's a little more guidelines, they may try to go after whoever they can to try to legitimize this whole initiative. The types of penalties are a little different. They're not crimes, they're not punishments, they're just administrative monetary penalties that the CRTC can just levy whatever they feel is appropriate against you. The stated purpose is that we're just trying to make sure people comply. The scary thing about the penalties are the maximum amounts that they can levy. For a contravention that an individual commits, it's up to $1 million. For a corporation, it's up to $10 million. Now, keep in mind that you got to keep in mind the intent of the legislation because, Nigerian prince inheritance scams are going to be hit a lot harder than the lemonade stand. And the CRTC has sort of verbally indicated, I can't give any guarantees about this, but they might work their way up in terms of, well, we might give written warnings. If an organization's really tried, they've put steps in place, they haven't blatantly, just sent out a bunch of spam messages, then we're not going to just slap down a $10 million fine. They're probably sending you a written warning. So it's something to consider, but can't give any guarantees because they might come out of the gate and just try to start hammering people. There's already a spam reporting center in place where people are apparently sitting by the phones ready to go for July 1st, just waiting for people to call in. There are factors to be considered in determining the amount of the penalty, such as the nature of the message itself. So, like, if it's a phishing scam, it's going to be a big problem. How many times you've done it, to how many people are you sending it, those sorts of things are all going to be considered in determining the amount of the penalty. You can also stop the penalty in its tracks by sort of settling or agreeing to a voluntary undertaking with CRTC, which is basically, yes, I've done wrong, let's agree to an amount that's lower than what you've actually levied me with, so it's basically a settlement. That will also, when private lawsuits kick in, that will also stop private lawsuits. Something definitely to remember is that officers, directors, so the executive of companies can be personally liable for what the corporation does. So if you're not careful about the due diligence procedures that are in place for your company, you could be personally liable if you're heading up the executive of that company. Also, to mention that companies are what's called vicariously liable for the acts of their employees. So if you've got a rogue employee that's somehow connected to your organization, then that might lead back to the company, which might lead back to you as an officer or director. So it's something to be careful with. CRTC, as I mentioned, will probably name and shame violators. Again, they're going to want to legitimize what's happening, so they're going to be posting this sort of thing. And then the last thing on this slide is the due diligence defense. So if you've taken reasonable steps, if you've gone through your databases, you've figured out your express consents, you've figured out your implied consents, you've figured out the expiries, you've done all you can to show, look, I've done everything that I could on behalf of this organization, or the organization has done everything it could to avoid this happening, you may be able to demonstrate the due diligence defense so that you don't get hit with the penalty. And that's something that's going to need to be fleshed out as the act comes into force. You see people claiming it to sort of see the boundaries of what's required for due diligence. Just to briefly note the private right of action, it does kick in on July 1st, 2017. And when it does, the individual can sue for $200 of contravention, mostly because their actual damages, are there any damages? I don't know, but they'll definitely be able to get the $200 and not exceeding 1 million a day. So this is not one person going to bring this claim. What this opens up is the possibility of class actions. And if you are just really not paying attention and you just continue to spam, then you may end up getting hit with a class action. So they've sort of given 3 years to sort of figure out how this is going to be monitored and how the CRTC is going to deal with the violations before they bring in this right of action, and just it gets through the courts and it gets very messy. The factors that they consider in assessing the damages are very similar to the CRTC in assessing the violation amount. And as I mentioned, if you get served with a notice of violation, there's no private right of action, so the court procedure stops entirely. So in terms of what you guys can do now, this is not necessarily before July 1st, although it's a good idea to do what you can. There's only 3 days left. Understand and document. So not just like, where are these lists coming from? We have, list A, list B, and list C. And list C is really obvious where these came from because it came from one of our partners, and we have consent throughout. But list A, this just, we've got this list here in our spreadsheet, and it came from somewhere, but we don't really know. Well, you got to find out, or you got to just get rid of that list entirely, or send out a message for July 1st to that specific list saying, look, we want your express consent. If you do adopt procedures for obtaining and documenting them, probably one of the hardest parts is going to be determining the timelines for implied consent. So, okay, do we have an existing business relationship with these people? Do we have contracts in force? Have they donated? When did they donate? How much? You need to figure out when they expire. So based on the timelines in the Act, geez, when are these going to actually expire? So how long do I have to turn these into express consent? Because the whole purpose here is to turn as many implied consents as you can into express consents. And for those you already have consent for, in some aspect, you try to turn it in before July 1st. And also those you have no consent for, you don't know where they came from, just fire out a big email before July 1st saying, we'd love to have your consent, here's 10% off. Again, taking steps to trigger those transitional provisions. So all that means is you're trying to extend from the 2-year time period. If you waited after July 1st and then you started a new relationship, you only get 2 years, you only get 6 months. If you do it right now, you may get 3, but it's getting a little late in the game to try to do that anyway. And then, of course, you probably want to designate someone in your organization to modify the form of all your messages to meet those CEM content obligations. So you want to make sure you're identifying yourself and your affiliates, and setting out the unsubscribe, saying they can withdraw their consent. Some large organizations are actually putting compliance officers in place to kind of deal with all of this, sort of centralizing where the messages are coming from, centralizing where the consents go. So you have a key person in your organization who can sort of champion that. But that's obviously difficult for smaller organizations who basically you're going to have to do it all yourself. And that's unfortunate, but right now there's no real way around that. If you do have agreements, such as legal agreements in place with other organizations in terms of how you deal with these consents, in terms of how you send out messages, you want to protect yourself. So if you bought a list, for example, you want to protect yourself by saying, well, if CRTC comes after us, we're protected because you're the ones who didn't get the proper consent. So you're going to have to indemnify us, which means make us whole. If we have to pay this penalty, you're going to pay us back, and try to protect yourself legally from these possibilities. You also may want to consider, if you do have privacy policies and email marketing policies, to update these, because it's only going to benefit your organization if you have these in place, because it goes to demonstrate due diligence. And all of these things, not only does it help you figure out where your consents came from and sort of where you're going with your lists and where you're going with your messages, but it helps show, if you ever do need to show, that this is what we did, here's our policy. Look, we changed our policy before July 1st or shortly after, and everything's in place. What a lot of people have done have actually put their messages on hold until they get their own house in order. So making sure that you have everything in place, and even if it means delaying that newsletter for another couple weeks until you get everything in place, maybe you want to consider doing that in order to properly modify the content of all your messages. I put this last link here because it is sort of the government repository. When it does put out any information bulletins, when they do put out any new regulations, there'll probably be some consultation documents. Fightspam.gc.ca is a good information source, as well as McInnesCooper.com has a good information source in terms of our CASL area, where we put a number of legal updates up, so you can take a look at those if you're still questioning things when you're browsing around and trying to figure out your compliance mechanisms. So now I'd like to open up to a Q&A discussion if possible, and I'm just going to toggle back to the Hangout here. So one moment, please. All right, so I'm going to open it up for the floor here if you guys have any particular questions that you'd like to have answers. Mark is going to be monitoring the online comments. There's a bit of a delay online, so we'll be about 30 seconds ahead of the people on the Hangout. Yeah.
With your organization, you're often sending out information so say someone's got an event and we'll just post it on our news board and stuff. That still qualifies, doesn't it?
Yes. The safest thing to do there is make sure that, confirm with the organization who you're sending it on behalf of that they have the proper consents, and maybe put some protection in place there for you, because you want to make sure that you're sending it on behalf of them, but you don't know whether they have the proper consents. So, and you might be the one, if you're not, diligent, or you're not sure about that, maybe you shouldn't be sending them until you know that they have consent. But if you're comfortable that they have consent, then you're okay, but you still have to follow the content requirements. Yeah, because that's going to be a commercial electronic message, no matter, even though you're sending it on behalf of somebody else. If you don't have those content requirements in place, then you're still sending technically a spam message.
But isn't that going only to your membership? Yeah, no.
Yeah, it depends on how constrained. Like, probably part of the people you're sending it to will be members, for which you have implied consent, but you still have to have content for. So you'd still want to. The basic rule is you want to cover yourself off by covering at least the content requirements. The consents, you might fall within a category of implied consent, but you want to make sure that that you're covered off in terms of the content requirements. Would be the smartest way to go about it. Yeah. Does anyone else in person have a question? I can kind of go back and forth too. It's fine. I'll take one from looks to be a Twitter question here. So if an email is sent from a software as a service website on behalf of a user to invite to an event, think Eventbrite, what is the impact? So again, I think that's very similar to your question. You want to make sure that they have the proper consents. So if you're sending it on behalf of a user, you need to make sure those users have consent to send to those individuals, and yourself, you want to make sure that you meet the content requirements. So it's always safe to allow or to include unsubscribe functions. One thing to note is it kind of goes back to the third-party, unknown third parties. So if the original user that you received the list from, they should be sort of asking for consent to send to you so that you could blast out. And in addition to that, your unsubscribe function is a general unsubscribe, so that if someone clicks unsubscribe on your message, you have to inform the people who you're representing, so on behalf of that, these people have unsubscribed from everything. That's how I would answer that. But again, it's a bit of a gray area there, and I know that of all the questions, I've gotten a number of questions on that, so it might require a bit more specific advice. And does that answer your question from yesterday, Toby? Yeah, that's what I thought. Yeah. So I've got another question here. My organization is a registered charity. Our electronic messages are intended to help us generate revenue / raise funds for our charitable purposes or are informational. Are these areas within the legislation that we should be concerned about? I would say if you're confident that the only things you're doing are A, sending a message to raise funds, or sending a message that's purely informational, then you're okay. You're excluded, because registered charities have an exclusion for when the message is primarily fundraising, and if the message is purely informational, then it's not a commercial electronic message anyway. So you would be okay. Again, I'd caution you if there's any sort of concern that this might include an element of commercial information. For example, like sometimes for charities you send out a message but you also have ads included, so you might be trying to fundraise at the same time by putting like ads on the side of the message or the newsletter. That is promoting commercial activity, even though it's not the main purpose of the message. It's one of the purposes of the message, so it's sort of a borderline you might want to consider. And again, all I can say to that is you're sort of best served putting in the unsubscribe. You're best off identifying yourself. I got some more here. In an email from a local news organization with the latest news, and then included is that, quote, this week's news sponsored by XYZ restaurant now featuring tacos. Does that sponsorship line make the email a commercial electronic message? Yes, I would say it does. I mean, because one of the purposes of the message is to promote commercial activity. It's as broad as that. It's framed very broadly. So if there's any purpose at all in the message, and that's what I was talking about with the email signatures early in the presentation. If you have an email signature that otherwise is completely innocent, but somehow says this email is sponsored by XYZ restaurant, which is now featuring tacos, then all of a sudden you're looking at a commercial electronic message and you have to comply with the legislation. Anyone else in the room before I take some more? So the next question, does consent need to be obtained on a per email basis or a customer basis? I.e., if we get consent from a customer who has 2 email addresses, is that good, or do we need consent for both email addresses? What if a customer changes their email? Need consent again? Really good question. Haven't encountered that. My knee-jerk is that if it's from the same account, like if it's from first name and last name are the same, I would say that you have consent from that particular person. I wouldn't say that the account really makes a difference, because if they do set up a new email address, you would likely still have consent from that person, as they haven't unsubscribed or otherwise indicated that they don't want to receive the message. So I would say that you're probably okay. So next question, is the use of website links or social media icons in the signature line of an email considered spam under the Act? Social media icons, no, because what you're doing is you're providing a passive link to where you broadcast information. You're not actually sending something that promotes commercial activity. That would be my response. If you're including links, then it probably depends on what the link says. Some links just have a content in them saying, save on this, save on, any kind of thing that could be interpreted as being a commercial message. If it's just an informational link, or for more information visit this, then I would highly doubt that that would be caught by the legislation. No? So can you just run that by me again? Mm-hmm. Yeah, good question. Again, I mean, it sort of sounds like earlier where you want to make sure that who's providing you the list in the first place. Are you harvesting them yourself? Well, that's the problem, because the first step would be trying to figure out where do we have consent in the first place, where are they coming from, like for those, patchwork lists, those are probably the most problematic in terms of complying with the legislation, because you've got no record of where the original consents came from. So I would do what you could to try to get consent before July 1st. You can now, before July 1st, you can just blast off to that all that list. And you might have to kind of parse through it and say, okay, well, some of these we know where they're coming from. We have implied consents for these. We have, a business relationship with these. But there's no easy answer to that question, I don't think. And I'd be happy to look into it more if you want to touch base with me directly. So that question I just answered, I'm sorry for the people online, was basically respecting media lists and not entirely sure where some of those people might have come from in the first place or where the consents came from. I got a question: if a user unsubscribes from a list, revokes express consent, then buys from you, e-commerce, do you have implied again? Yes. Actually, that's where I talked about the practical nature of what you want to be careful of, because my thought before I read the legislation was, well, if they unsubscribe, they don't want to hear from you again. But the law is not quite that harsh in this respect. If they transact with you again after they unsubscribe, the law allows you to send them another message asking either for express consent or just sending them a commercial electronic message. But a lot of marketing software will actually put them on a block list so that you can't do that. So you need to consider for your organization and your goals whether it's okay for you to be sending the messages if they've already unsubscribed. Like if it's something completely different from the thing they unsubscribed from, then maybe that's fine. But if it's very much related to what they were already getting messages from you on, then maybe you want to not send them any more messages. But you are allowed, yes, under the legislation. You do get implied consent. All right, that's all the questions I have online. Anyone else?
In terms of registered charities,
yes.
Does the law distinguish between fundraising activities and revenue generation activities? So say I'm a community theater group, I'm a registered charity, I'm promoting a concert.
Mm-hmm.
Is that considered fundraising, or is that just considered revenue generation? Is there a difference in your charity?
The stance of the CRTC, and this is kind of a very much a hot button issue for registered charities. So the question was whether there's any difference between fundraising activities and sort of revenue generating activities. I think the easiest way to answer it, as long as it's funneling into the pool of the charity, no matter the means of doing it. So like it might be a distinction without a difference in terms of how the law works. I think as long as the end result is there's money flowing into the charity, then you're excluded. But there hasn't been a regulation on that, and we'll have to see how that plays out. But that's what most people have been interpreting it, as long as eventually it results in funds to the charity. But it's trying to figure out when are you ever going to send a message that doesn't do that. I mean, they had to have something in mind to not be covered. You know what I mean? But it might just be factual. Like all of a sudden you're like, I really want to send a message to this, but it doesn't. It's not quite related to funds actually going in our coffers. So then the warning bells should be going off. And until we get any more guidance, that's sort of that's been the stance on it so far. Yeah. So just got another question online. Is the promotion of billing programs such as equalized payment programs or e-billing considered spam? They are not selling a product but are promoting a type of billing from a company. Would including information about these programs be considered spam? I would say yes, because the billing programs themselves are a form of executing commercial activity, and you're promoting a software that will assist in commercial activity. I'm not 100% sure, but it seems to me like you're very close to the line because you're promoting a certain type of billing from a company, which essentially means, as far as I'm reading the question, that they would have to install this particular type of software, and thus someone would have to buy the software. So I think it generally falls within the definition of commercial activity. So if you are promoting such a thing, I would just I would try to have consents for that and also follow the content requirements. Anyone else?
that be sufficient for permission? Would I need each individual person to take a box or something?
So the question was, there's a guest book at a new interpretation center that basically provides some space to for a user to write their name down, and at the top of each page of the guest book there's sort of a description of what they're going to use your email address for. Is that sufficient for CASL? My answer to that would be yes. I think that's okay because the request for consent is prominently displayed. The only thing I would think about is, since you're asking for consent, for those who have already signed it before July 1st, those are probably, as long as you have enough information in terms of what it's going to be used for, then they're probably okay. After July 1st, though, you'll need to include a statement on you may withdraw consent at any time. So you need to make sure you look at the actual provisions on how do I request express consent, and make sure you have all the elements of those on your guest book page. So the next question is, what about public organizations that are conducting fundraising with commercial companies, i.e. schools, nonprofits? Are they impacted by CASL? Oh, and that just went away. The question just went away. Oh, here we go. What about public organizations that are conducting fundraising with commercial companies, i.e. schools, nonprofits? Are they impacted by CASL? Yes. If you're not a registered charity, then you're not excluded from the Act. So, you know, if you are a not-for-profit, you may have implied consent if the people have previously donated or if they're a member of an association. But if you're a public organization that's conducting fundraising with a commercial company, then yes, you better comply with CASL, because the only people that are carved out entirely are registered charities. Another question that's kind of harking back to the software as a service question. If a site is sending an invitation to a free workshop, so professional development workshop, to an email address is entered by a user of the service, should the contact info in the email be that of the service or the sending user? Just maybe because I'm on the spot here, I don't really understand that question, and it's probably my fault, but I will, if you just want to send me an email, I will follow up with that question directly, because it looks to be a bit nuanced anyway. I think that's it. Any more? Any more questions I can help you guys with? Okay, well, thanks everyone very much for attending this afternoon's presentation. I hope it's been of some benefit to you. As I mentioned, you can contact any member of our CASL team, myself or David Fraser or Thomas Raffi, and we'll be happy to help you continue to try to comply with this beast of legislation. Thanks again, and feel free to, we'll be posting this on the CASL page at McInnesCooper.com, and thanks very much for attending. Take care now.